Good evening, everyone. Is this working? Nope. Is it working now? Okay, great. Well, welcome to everybody. I'm so glad you're here for our Commonwealth Attorneys Candidate Forum. My name is Elaine Head. I am co-president of the League of Women Voters of Montgomery County. And I would like to thank our co-sponsors for this event. And would you please call when I mention your group? Would you please stand? The Montgomery County, Radford City, and Floyd County chapter of the NAACP. Okay, the New River chapter of the Virginia Interfaith Center for Public Policy. Thank you. And the News Messenger. Thank you very much for your help. Here's some specifics about this evening. Please, everyone, turn off your communication devices. Thank you. We have volunteers who are distributing little Post-it notes or cards for you to write any questions of the candidates, and they will be collecting them from you, so please just raise your hand and they'll come and get it. These questions will be reviewed by Carol Linker and Bobby Littlefield, and Mary Johnson and Jean Finley will be our timers. This forum is being videotaped. It will be put on our website, which is lwvmcva.org. It will also be shown on WTOB, and you may also go to YouTube and then go to Montgomery, VA. Voter guides for all the candidates running for election will be put on our website, and paper copies will be put in the county libraries. And the voter guides for the President of the United States and the 2 Virginia candidates for Senate are in the lobby out here. The voter guides contain short biographies of the candidates and responses to questions posed by the League. The League does not edit their responses. They simply cut and paste their answers together, and they are received for each candidate. And lastly, Mary Hauska, our voter service chair for the League of Women Voters, will be the moderator this evening. Mary?
Thank you. Good evening. I want to introduce our 2 candidates. Peggy Frank, the candidate for the Democratic Party, and Mary Pettitt, who is the incumbent, who is the candidate for the Republican Party. We've just tossed a coin, and Peggy won, so Peggy is going to start with her introductory remarks.
Thank you, Mary. I'd like to thank the League of Women Voters and their co-sponsors for holding this forum. When this election cycle began back in the spring, I researched and prepared an evaluation of what my concerns would be for this office if elected. Having been a prosecutor previously and currently, I know what needs to be accomplished. My opponent has exhaustively written and blogged about her experience. The truth is that I've been at this profession a few years longer, have had 1 more capital murder case, have made new law in the Commonwealth on child abuse, and have prosecuted cases in Montgomery and Pulaski counties for over 21 years. The really important issue in this election is not a comparison of experience, but leadership. What ideas, what initiatives, what management techniques, in what ways can I elevate this office to better serve the citizens of Montgomery County? I would submit to you, the citizens, that you are entitled to the very best leadership available, including improved use of information technology, bringing revenue to the county by collecting unpaid fines and costs, and by making the office more user-friendly to the entire community, including law enforcement and all court officials. In July, I personally met with our sheriff and police chiefs asking what improvements they would like to see in the performance of the office. Universally, I found that these leaders wanted better communication from the Commonwealth and a more considerate relationship with its officers. I have met with our Circuit Court Clerk, Erica Williams, and have forged a joint commitment to take the judicial record-keeping system paperless, resulting in thousands of dollars in savings. We have to learn to do more with less. My opponent's reaction to these ideas is that the office is fine, that the status quo is acceptable, that the office is not large enough to need a leader, that her job is to prosecute. I know that you can be a wonderful prosecutor and an effective leader at the same time. The choice for voters in this election should be clear. Do you want to elect a leader or a follower?
Mary Pettitt.
Thank you. I also am very pleased to be here this evening and to finally have an opportunity for people to see both myself and my opponent to speak with you at the same time. I have been an attorney for over 20 years and a prosecutor for approximately 14 of those. This is the third Commonwealth's Attorney's Office in which I've served. Each time I've moved either to a larger jurisdiction or to a position that carried more responsibility. I served as Chief Deputy in this jurisdiction for the last 7 years, and I now serve as your Commonwealth's Attorney. The most high-profile case that I ever handled was the capital murder case of William Morva. In that situation, the prisoner, William Morva, escaped from his guard at Montgomery Regional Hospital. He killed the security guard there, Derek McFarland. He then ran to the Huckleberry Trail, where he, the next morning, killed Corporal Eric Sutphin of the Montgomery County Sheriff's Office. He was charged with 3 counts of capital murder, and he was convicted on each one of those counts after a 2-week murder trial in Abingdon. That case was handled in 2008. In the past 4 months, I have prosecuted a rape case to a jury, resulted in a conviction on rape and sodomy, and a recommendation of 16 years in prison. I've handled 2 first-degree murder cases and co-defendants from a murder that occurred in Christiansburg. In that case, each defendant was sentenced to serve 40 years in prison. I've also done motions in the attempted capital murder case involving Jonathan Agee and the shooting of Trooper Brannock. My trial experience as your Commonwealth's attorney will make all the difference if it's you or your family that's involved in a crime in Montgomery County. Although office efficiency is important, you deserve a prosecutor with the skills and trial experience that I have.
We'll now start our questions, and I guess I'll start with my reserve question here. A local defense attorney has been critical of the way the Montgomery County Commonwealth Attorney's Office handles the sharing of information gathered by the office. In Montgomery County, a defense lawyer must travel to the Commonwealth Attorney's Office and to make hand notes of anything in a defendant's file. Defense attorneys are not permitted to copy or scan that information. In other counties, the Commonwealth Attorney's Office will fax copies of this information to defense lawyers. Should the Montgomery County Commonwealth Attorney's Office change its policies? And I'll ask Mary first.
The Commonwealth Attorney's Office is not going to change the policy at this time. I have asked defense attorneys to please work with me and provide me with ways that we can maybe better accommodate their needs. But what you need to understand is my office is here to prosecute crimes. I'm not here to work for the defendant. What the defendant is entitled to is a copy of any statement that he made and to know what his criminal record is. Our office provides much more than that. We provide the same thing that's done in Roanoke City, Roanoke County, Body Tot, Salem, and many surrounding jurisdictions. That is an open file policy. Defense attorneys are asked to come to our office in exchange for the fact that we're giving them so much more information. They are not required to hand copy. Many of them bring a computer, type things in. They can also dictate, but we do not provide a copy of that, of our reports to them. There are 2 primary reasons for that. One, the police departments don't want us faxing or photocopying those reports. The state police report says right at the bottom of it, this is not to be disseminated. So if I was to do that, I would be in violation of state police policy and their trust in providing me with that report. In addition, if you're the victim of a crime, not only is your name and address in that report, but your social security number, your date of birth, and other identifying information. If I give that information out by faxing it or emailing it to a defense attorney, it makes it very easy for them to then copy it and hand it to their clients. I have talked to a number of defense attorneys, and they've told me that they do exactly that when they get it from other jurisdictions. In addition, there are just safety and security issues about it, and I feel I would be violating your trust by giving that information out.
Thank you. Ms. Frank?
I currently work in the Commonwealth Attorney's Office in Pulaski County with Mike Fleener. When we get a discovery motion and asking, for discovery in a case, what we do is redact really the guts, the facts of the case, and provide them with the facts of the case, and also with also recite what their criminal history is. We don't give them the criminal history, we don't give them the report, but we take out the information that gives them enough information that they can prepare for court.
Okay, thank you.
I'm sorry, but do I get a chance for rebuttal?
Surely.
Okay. What I will mention about that then is that they are actually providing the defendant with less information than we are. They may be giving it to him in an easier format so that the defense attorney doesn't travel to the Commonwealth Attorney's Office, but they are giving him less information. I will also say that they're now spending Commonwealth Attorney's Office time and resources to redact and presumably photocopy something, which is again using more paper.
Thank you. Okay.
Can I respond to that?
Yeah, go
Okay.
ahead.
We're not using more paper, we're faxing it out. We don't send it by mail, we fax it out, so it is not using more paper.
Well, I guess my question about that then would be, how do you redact something and not, somehow you've now marked up either your original or you've made a new copy to redact it and fax it?
Are we done?
Yeah, we're
Yes, okay, thank you. This time, Ms. Frank, you're on first. Where do you stand on prosecuting capital crimes? Under what circumstances would you ask the court to convict someone of capital charges? That is, charges that could result in the death penalty.
Well, I have been involved in 2 different capital murder cases. The most recent one would have been in Pulaski, Jeff Thomas, who killed Tara Muncie, and in that case we did ask for the death penalty. It was a 15, 16-year-old girl who was shot several times, both through her ear and in the chest, and body left out pretty much in the wilderness off of Bell Spring Road. In that type of case, definitely would pursue capital murder and the death penalty.
Ms. Pettitt.
If I understand the question correctly, it is under which circumstances would you ask for the death penalty? That's actually set out by statute. You can be convicted of capital murder and not have the Commonwealth seek the death penalty in the case. They would be seeking just a life sentence. So the criteria for when you can even request death are very specific, and it needs to be a crime that would be very vile and heinous. In other words, something beyond just one gunshot has killed someone. It becomes capital murder when it's things like a police officer that's involved or in the commission of certain other crimes. So that, again, is set out by statute, and I would certainly follow what the statute says. I find it interesting that my opponent talks about the Thomas case, because my understanding of that is that that is a case where there was a death penalty was involved the first time around. The case was reversed and sent back, and then there was a plea which took the death penalty off the table, and he's now serving life. I would also, again, ask when the Thomas case was tried and when her particular involvement in it was.
That was in 2000.
Do you want to rebut more than 30? You still have 30 seconds.
Okay. That was in 2000. Right now we have a couple of new murder cases in the office, which may, after examining it, I know Mr. Fleener is looking at it now, may both be capital murder cases.
I'm expecting another, no, okay, okay. Peggy Frank advocates moving the Montgomery County Commonwealth Attorney's Office from keeping paper records towards computerizing its records. What are the pros and cons of doing this? I think it's your turn.
I think it is. Well, I think the pros of it are that it would reduce file storage in the office. At this point, what we need to look at is we have a new courthouse and they've provided space, and so file storage is not a real issue. The real thing that I think we need to look at here is what we're talking about, costs to be able to do this. Okay, we're going to have the cost of the software, we're going to have the cost of someone to scan things in, and we would have, I think, the cost of laptop computers to use in the courtroom. I think the best example that I've been able to come up with on this is to look at what the circuit court clerk's office is doing. My understanding from the judge in that is that the cost of that system was anywhere from $25,000 to $40,000. I have attempted to get some information about the cost of doing a paperless office in a Commonwealth Attorney's office, but since there's only one in the Commonwealth that's doing it, there's not a whole lot of information. My short version on this would be that my opponent has spent about $40,000 of her own money on this campaign at this point. She now wants to spend at least $20,000 of your money to save $2,000 in paper. $2,000 or less is what my office spends every year on paper. So we're not talking about big savings. By the time you recoup the $20,000, the system we're using would be obsolete.
Mrs. Frank.
Well, what I've learned from our circuit court clerk in Pulaski, Madda Cruz, she has in different times applied for grants and gotten grant money to help out with her office and get some things for her office that she otherwise would not be able to afford. That is certainly one thing that I would pursue is getting grant money to get this process going, because I think that we do need to modernize the Commonwealth Attorney's Office, and it would be saving money ultimately.
Okay. No rebuttals? Okay. How do each of you determine whether cases are prosecuted, pled out, or dropped? You're first.
Well, all the cases that I take to court, with district court, let's start with district court, you know, we go in, we prosecute them. If there's not enough evidence, obviously, to prove a case beyond a reasonable doubt, then it's not going to go anywhere. In circuit court, it's a little different. By the time we get to circuit court, a lot of our cases come by being from preliminary hearings in district court and being certified to circuit court. And we oftentimes have officers come in with reports where they want to have direct indictments going straight to circuit court. And if that's the case, we prepare the indictments and present them to the grand jury. And follow up on them once they're indicted. You know, they're scheduled for court. We have a status day. The first time they come to court would be a status day in circuit court, so that it can be set for either a plea or a trial at a later date. And then on the later date, we would, you know, decide based on a lot of times sentencing guidelines that we provide. If there's a plea agreement, it's usually within the guideline range, or if it's a bench trial, then the judge is going to be the one who sentences them.
Okay. Ms. Pettitt.
Two things that I start out looking at when I'm deciding whether to offer some sort of a plea agreement are protecting the community from future crime and punishment for the crime that's been committed. In looking at those, I look first, obviously, at the strength of the case. I mean, our job is to prosecute cases that we can prove. It's not to prosecute people who haven't done something. So I'm going to look at the strength of the case. I look at the person's criminal history. I look at their age. If it's someone who's 50 years old and they've been a good citizen and they are now charged with a crime, I'm going to feel differently about that than somebody who's 20 years old and was in trouble as a juvenile and has continued to be in trouble as a young adult. I'm going to speak with the victim if there is one in the case, and also with the officer that's involved. A lot of times the officer has had prior experience with the person that's before me, and they can tell me whether or not they are still involved in illegal activities. Finally, in deciding what would be fair, I look at what's going to make a difference to this particular defendant. I would like for everybody to get back on track and follow the law and be a good citizen. In some cases, I think what makes a difference to a person could be a fine. In some cases, it's jail time. In some cases, it's substance abuse treatment, or having a probation officer following along and getting them, making sure they get a job and do what they're supposed to do. So I try to weigh all of those things and come up with something that's agreeable to both the victim and the officer that have been injured or put time into this case, and also what I feel is the right thing to do in that particular situation.
Okay. I think this one's going to be yours. Discuss the various kinds of leadership required in the Commonwealth Attorney's Office and describe your plans to be a responsible leader.
The different kinds of leadership, I think, that are involved in the office is first and foremost, the job is one of a prosecutor. And part of that is to be able to prosecute the toughest cases and for your staff to know that you are able to handle those cases. The second part of that is that I do have 7 attorneys that work for me. And so part of my leadership is to make sure that they are able to take on new, different kind of cases, that they stay energized and enjoying what they do, and that their skills improve so that they can take on more and more responsibility. I know we had a new murder case we were talking about in our office, and I went to an attorney that I didn't think had had a chance to do a murder case yet, but I felt was ready to do that, and she was very excited to have the opportunity to be involved in that case. Now that also means that I'll be working right with her to make sure she feels comfortable in what she's doing and is moving along like she should. I think the other part of the leadership in the office is certainly administrative, and I have a terrific support staff. They are capable of handling many, many things in the office, but they also need to be able to come to me and ask for assistance about those things. Just as an example, this past week, I had an attorney that was in a jury trial yesterday and today. I spoke to her obviously before the jury trial. I spoke to her yesterday evening after they had concluded for the day, just to see how she was doing, if there was anything I could help her with. And we talked again today at lunchtime to see how things were going. As another example, I had another attorney in the office come and tell me about a phone call she'd gotten from law enforcement, and she felt like she needed some guidance on how to handle things there. So we talked about that, and then she was able to make some follow-up phone calls on that. So I think that's what being a leader is about, is helping your employees to advance.
Thank you. Ms. Frank.
Well, I think as a Commonwealth attorney, obviously, if you're in charge of the office, that you do need to be there for the other prosecutors in your office and the other employees that are in there. You've got victim witness people as well that are a big part of the court system. So, you know, I certainly know that as a Commonwealth attorney, you are a leader in the office. You do have to help the others there in order, particularly if they haven't been there very long. We have one new attorney in our office who just got news that she had passed the bar, and she's been working with several of us in the office, going to court with us and getting some experience that way.
how does the office work with victim assistance programs? Ms. Frank?
Okay, we have 2 victim witness people in our office. One, Bill Demery, goes to district court. He deals with witnesses. He often gets them in. They want to come in and talk with us ahead of time, and we talk with them. The other person, Suzanne, goes to J&D court and deals with the J&D cases and helps people.
What's J&D?
Juvenile Domestic Relation Court, and works with victims from that court. And I think they are both very, very necessary people in the office and very vital in our office. Mr. Demery, in addition, deals with a lot of restitution. When restitution is ordered in cases, he follows up on it and keeps up with that in our office.
Okay. Ms. Pettitt?
The victim witness in our office are tremendous liaisons between the attorneys and the victims in cases. My office has court 5 days a week. A lot of times it's difficult to get on the phone and talk to an attorney. There are many questions that victim witness can answer for you. They can let you know if you're the victim of a crime, they can let you know about upcoming court dates. They can let you know if there's going to be a bond hearing in a case. They can talk to you about restitution and gather that information. They can talk to you about, what's the most important thing to you in this case? Is it that you not have any more contact with this person? Is it that they go to jail? Is it that you get restitution? So they are a tremendous help to the attorneys in that fashion. We have 3 victim witness people in my office. They each work with a different part of the court system. And I will tell you that they are so well liked that we've had, birthday gifts brought and invitations to weddings and things like that. I mean, they often really become a friend to people that are going through a very difficult time in their life. And they are a tremendous help to me as an attorney in providing information and best utilizing my time. And they also are able to provide information about things like counseling or maybe housing resources or GED programs. We try to keep a lot of that in our office because those can also be needs of folks that come before us, and we try to facilitate their access to information that they might not otherwise know about that's available in the community.
Okay. What does it mean to be the chief law enforcement officer?
Well, the primary responsibility of the Commonwealth Attorney's Office is the prosecution of crimes. Our office is not one that generates a lot of money for localities. In fact, we don't accept any money in our office at all. That's not our function. What we do is when law enforcement officers are out there working hard and risking their lives and people are charged with crimes, then it is up to us to make sure that those cases are fairly and effectively presented to the court, whether it be a judge or a jury. And that means that as a chief law enforcement officer, we're sort of the end of the road there. And when the officers bring us a case, if we don't do our job, then they're really just wasting their time. I really appreciate what law enforcement does for us. I mean, without the rules and law enforcement working in our community, then none of us are going to be able to live the way that we do. We wouldn't have the opportunity to come here and talk the way that we are tonight. And so from that perspective, I feel like it's very important that I try to honor the cases that they brought, to honor the victims' rights and things, and to show professionalism and skill in being that end of the line for law enforcement in the court.
Mrs. Frank?
Yes, I likewise believe that the Chief Commonwealth Attorney does need to oversee the office. They're in charge of prosecuting the cases that are brought to them from crime in the community, and take, as we know, law enforcement are the ones that bring the cases to us, and we want to make sure that they realize that we take their jobs very seriously, because they are putting themselves at danger out there on the streets every day. And we will take their cases seriously. We don't turn down, as far as I know, I don't know that we've turned down any cases that have come through the office, because most of the officers that we work with are very thorough. They're willing to go find more evidence if they need it. If we tell them we need something else, they're willing to do that, and we help them in any way that we can.
Well, this one is a change from the previous ones. Given the prevalence of meth labs in the county, what issues do these cases present for the office, and what is your experience in handling meth lab cases? Ms. Frank, you first.
Okay, I'm certainly aware of the manufacture of meth cases. It has definitely been on an increase recently. It requires very specialized equipment or advanced training to deal with meth. Mobile labs are prevalent and make seizures even more complicated. Rural areas are popular because lab produces strong odors. The drug task force and local departments are the ones who investigate. The single key ingredient for meth is ephedrine, and it's a controlled substance, and often the police will be looking to see where large quantities are being bought and tracking it down to see where some of the meth labs are. So I know that Drug Task Force now are taking it very seriously and investigating those types of cases.
About 3 years ago, we started getting some training in my office about the manufacture of methamphetamine. And part of the reason for that is because it was prevalent north of us and prevalent south of us, and we knew that no matter probably what we did, that it was going to end up here. Since that time, and if you had asked me then, I would have told you I'd probably never seen a case where a person was charged with either manufacturing or possessing methamphetamine. The reality of it is now that if I picked up a stack of 10 drug cases, probably 8 or 9 of those involved methamphetamine. It's very different from many other drugs. The people that are making it are generally making it for their use or use within the little small group that's making it. You get 5 or 6 people together. They may be people of various different ages and socioeconomic backgrounds. For about $40, they can go out and buy what they need to make meth to last them for a few days. What we have discovered is that if we let those folks out on bond, we're going to see them again within about 2 weeks. We've worked very hard to educate our judges by putting experienced officers on the stand to give information about meth, and we've now convinced our judges that in the majority of cases, people who are charged with manufacturing should not be released on bond. In addition, there are very stiff penalties for people who are manufacturing methamphetamine. The reason for that is because it's easy to transport, it's easy to have in a coat pocket, on the side of the street, or in your house where there are children. And so for those reasons, a lot of the mandatory time is 3 years or 5 years. Until there is some sort of successful treatment program for the use of methamphetamine, there is not a whole lot that my office can do other than enforce the law and put these people in jail so they aren't out in the public.
We have a question about working with other law enforcement. How will you, how will you work with the community to ensure that public safety is a shared commitment among the police, the sheriffs, and the Commonwealth Attorney's Office? I think you're first.
A shared commitment. I absolutely think it's that. I told some officers last night that, I won't get it right 100% of the time, but when I work together with them, we're all going to come a lot closer to getting it right 100% of the time. Sometimes that means doing training with officers. We've done all sorts of group trainings, whether it was in sexual assault, rape cases, whether it's in drug cases, murder cases, where prosecutors in my office have gone off to a training with a law enforcement officer. Sometimes it means doing a ride-along with an officer so that we understand more about their jobs and the challenges of that, and they understand more about the challenges of our jobs. Sometimes it means doing things like take back drugs and standing out in Blacksburg at the rec center and having people come up and give us their prescription drugs so that they're out of the house and aren't accessible to people who might steal them or to teenagers that might want to experiment with them. Sometimes it means going and talking to DARE groups in conjunction with officers. So we do a lot of different things with officers. I think we have a very good relationship with all of the law enforcement that are here. I encourage people to find a police officer and ask them. They bring us cases and deal with us every day. They know how our office is to work with, and they know what we do with their cases, and they seem to be happy with the way we're doing it.
Okay. That's right.
Well, I can say similarly that the law enforcement that we work with are, seem to be very pleased with the work that we do. We definitely keep our training up. I know that I've been involved and done all of the different major programs, from Top Gun to Trauma to Trial and several others. And often there are training that involves both a law enforcement person as well as a prosecutor, and I have participated in those and would participate in the future, because I think it's important to support our law enforcement that are out there putting their lives on the line every day.
I think this is yours first. How would your office handle the collection of delinquent court costs?
Well, there's several ways you can deal with delinquent court costs. One is you can, I guess, do it within your office itself and collect it. Another means is getting someone outside the office to collect it, which means, they would be getting some of the money, obviously. And then the treasurer of the county also can collect those fines and costs. If it means that there'd be more money for the Commonwealth Attorney's Office, and there's, you have the employees or an employee who could be in charge of that, and it would be worthwhile financially. I mean, that's something I would definitely want to look into. That might be a way to go.
Mrs. Pettitt.
Well, my opponent does correctly state the options that are available for cost collection. Let me tell you that if you have somebody outside of the office do it, they're going to take a third of what they collect right off the top. If you have the treasurer do it, I'm not sure I'm aware of a treasurer anywhere that is willing to take that on, and it is something that by statute is required that the Commonwealth's Attorney's Office come up with a way that they're going to collect those delinquent costs. In Montgomery County, we are one of 6 jurisdictions in the state that chooses to do it in-house. We do that at the absolute lowest cost of any of those 6 jurisdictions, or any other method that any other Commonwealth Attorney's Office is doing. It costs 0.02% of what we collect in order to do our collection costs. What we do is we use somebody who's already employed in our office. They spend a few hours of their time, and they're able to become a collections unit for us. As a result of that, and this is a long-term, ongoing type collections process, we are able to bring in an additional $100,000 to the county in each year. That doesn't go to the Commonwealth Attorney's Office. So it goes to the county, goes back into our pockets as taxpayers, and is a significant chunk of money for the county to be able to use for other expenses. So I think that that is really the way to go. It's a method we've used for quite some time, and I don't see making any major changes to the way that that is done in our office.
Well, we have someone in the audience who is interested in protecting citizens' constitutional rights, and I'm sort of going to combine these two questions. One asks, what will the Commonwealth Attorney's Office do to protect all citizens' constitutional rights? And then, does the Commonwealth Attorney ensure that citizens' rights are protected if the police or the sheriff's office violate those rights?
Well, my office is about prosecuting crimes. It's also very much about doing justice. And that does not always mean obtaining a conviction in a case, just as it doesn't always mean asking for the maximum penalty punishment-wise in a case. As I said earlier, what I would really like is for everybody to get back on track and be a good citizen. That's probably not going to happen. I'm not Pollyanna, and I don't believe that, but I do try to look and see how we can work towards that. Now, that being said, that means that if you are falsely accused of something, or you're accused of a crime and that's not the one you did, maybe you did something else, then that's very important for me to look at that as a prosecutor and figure out, what is just? Has this person done anything wrong? Can I prove that they've done something wrong? And citizens' rights, I think, go both ways. Maybe you're falsely accused. Maybe it's also your rights that were violated when you're the victim. If it's your home that's broken into, if it's your loved one that's been harmed in some way, those are also our rights to feel safe and secure in our homes. And I'll tell you one that comes up a lot of times, and in fact, a lady that I knocked on her door wanted to make sure that I remembered this, and that's children in schools. I mean, we expect our children to be able to go to school and be safe and feel safe and secure there so they can learn. Her son was someone who had been assaulted while he was at school. She was very happy with our office. It had happened several years ago. Her son had to have surgery. I mean, it was a very serious offense. And she remembered talking to our victim witness coordinator. She remembered her by name, and she just wanted me to know that that was very important what we had done, and she wanted us to continue to do that type of work.
Mrs. Frank.
Thank you. I think as a prosecutor, that is one of our number one jobs is representing the citizens in our community, those who are victims of crimes, and also to prevent crimes in the community. That's what law enforcement is out there to help with that part of it, to protect our citizens' rights. But when a case is brought to court, cases aren't always, foolproof. I mean, they may, at first glance seem it may be probable cause standard, but before we can complete a case, obviously it's got to be beyond the standard or beyond a reasonable doubt. And, working with the citizens and explaining to them, should it not reach that level, that, we may not be able to go forward. But and then in other cases, sitting down with them, have them come into the office and, feel like, they can talk to us and have our support, when they're in court.
Okay. Here's an interesting question. Think of a particularly difficult case that you lost. What did you learn from that case to help you improve in the future? Mrs. Frank.
Oh, goodness. I'll have to think a second on that one. I can't think of a difficult case that we've lost. I mean, I really can't at this point. I may come back to, you want to come back to me in a minute?
Rebuttal.
Thank you.
Ms. Pettitt.
Maybe Ms. Frank could tell us about a difficult case that she has won too, but I'll tell you about a difficult case that I've lost. I had a rape case. It was a Virginia Tech student. She'd been out drinking, not an uncommon thing. She went back to an apartment with a young man that she knew from work. He'd also been drinking. When she woke up, whether it was because she had passed out or because she was tired after a long day, he was on top of her having sex with her. That wasn't something that she felt like she had consented to, so he was charged with rape. That's a difficult case for a lot of reasons, just starting right off the gun there. But I felt like she was adamant about what had happened, that the young man had done something wrong, and I believed her. And so from that perspective, while I may have told her right from the beginning, this isn't going to be easy, and I'm certainly not promising you a conviction, if you want to go forward, then I'm going to be behind you, and we're going to do this, and you will at least have your day in court to be able to confront him. Now, what I would say happened in court, where I learned something, and it is a case that I ultimately lost, but in voir dire, when I got to question prospective jurors, this was a situation where I didn't have any big DNA, fancy scientific evidence to show anybody. I didn't have any other witnesses. And so I said to my prospective jurors, if you listen to the victim in the case and you believe what she tells you, will that be enough for you to find the defendant guilty of rape? Well, you should have seen the hands fly from the people who said no. And I almost ended up having a mistrial by not having enough jurors there. What I learned from that is not necessarily that that's a bad question, but how high that standard is, that even if they believed what she said, they still weren't going to be willing to convict him.
Do you want to use your 30 seconds of rebuttal time?
Certainly. That definitely refreshed my memory about a case that happened, it's been a while ago, and it was as well a rape case. And numerous witnesses, DNA, even had an expert from Richmond come in, and the trial took several days, and, you know, unfortunately, the jury found him not guilty, and having to sit down and talk with, you know, the victim, you know, involved. We had been with her, provided lots of support for her from various, you know, victim witness people and everything. And, you know, it can be troubling when things like that happen.
I have a follow-up to that, and that would be to ask Ms. Frank if that was the Druckenmiller case, and if it was, then I would be interested in when was the last jury trial that she tried?
I can't tell you the year that was, but it was here in Montgomery County, and the last jury trial that I've had would have been the Jeff Thomas case in Pulaski County.
And that was the one you said was in 2000?
Yes.
I'm curious, then how are most cases settled? May I ask when your last jury trial was?
June.
Okay, this year. Mm-hmm. Right.
Just to give you an idea, my office has had probably an average of 2 jury trials go. I know there was 1 month this year where we had a jury trial every single week during that month. There may have been more than 1 month when we had that. So, you know, over this year, we're now in the 10th month. I would say we've had at least 20 jury trials. It is a fairly common occurrence. It is a time-consuming way to handle a case for something that could probably be tried in front of a judge in a few hours. It becomes an all-day type of a case, but it's something that the defendant's entitled to. And sometimes the Commonwealth wants to ask for a jury, and sometimes the judge asks for a jury. So it's a regular thing that happens, and it's a skill that you need to have regular practice in and be able to advise other attorneys in your office how to handle those situations.
Do they handle things differently in Pulaski County? How are cases settled in Pulaski County? Before a judge rather than a jury?
No, either side can choose, ask for a jury, both the defendant and the Commonwealth attorney. And there are some cases that, you know, that, I mean, we other than the cases that have come up here recently, the couple of murder cases that have come in the last month that have said, you know, may become capital cases, we have not, you know, had other, you know, murder cases. I mean, those are the first ones we've had in a while in Pulaski County.
They don't have as much trouble there. It is time for the closing statements, and this time you begin, Mrs. Pettitt.
Let me just say that that's not considered fair under the attorneys rules there. But in any case, I'll be glad to do that. Let me address first the office efficiency and budget. And we've talked about some issues with that, and my opponent keeps attempting to make that the main focus of this office, and it's not. I will give you a couple of more facts to guide you, because I think our office is very efficient and works well within the budget. Based on records maintained by the Supreme Court, my office closes 40% more cases in General District Court and 28% more cases in Circuit Court per year per attorney than my opponent's office in Pulaski. My opponent's most recent flyer talks about our budget going up 8% over the last 3 years. What she doesn't tell you is that 5% of that is for the Virginia retirement system. The legislature required that everybody who's a county or state employee start paying 5% towards that retirement system. In order to not reduce our salaries by 5%, they turned around and gave us a 5% raise. So that's 5% of the 8 over the last 3 years. I'm not sure if my opponent doesn't mention this because she doesn't know that, or because it sounds better just to say that my budget has gone up 8%. What the real truth is that over the last 5 years, my office has returned unused, on average, 12% of the budget that was allocated to it by the county. Every year, we've come in under budget. I hope you listen carefully to what my opponent said about her trial experience. At the end of the day, I'm an advocate for you all. If something happens to your family, I'm the one that's going to be in court talking for you. When your loved one is murdered, you don't care about office efficiency. You want the prosecutor with the experience and skills to get justice for your family. The men and women who wear the badge in Montgomery County know that I'm the Commonwealth attorney that they want in the office. That's why I've received the endorsement of both the Fraternal Order of Police and the Police Benevolent Association. I hope that you will join me in their support and vote for me in November.
Thank you. Mrs. Frank.
Thank you. I want to thank the League and co-sponsors once again for allowing our positions to be heard. You've heard from two somewhat similar but very different candidates tonight. Both are veteran prosecutors. Only one is a progressive leader interested and willing to take this public service office to new levels. With the financial condition of our county, we can no longer accept the status quo in leadership. Our county has maxed its borrowing power for the near future building schools and county buildings. We are potentially facing another huge tax increase in 2013. Our constitutional officers, like the Commonwealth, must learn to be better leaders and managers of their budgets. We must learn to do more with less. The best way to accomplish this is through going paperless and improving every aspect of information technology. Wise County, Virginia has reduced its judicial system paper flow by 65%, saving thousands of dollars. I have arranged for private matching funds to present to the Board of Supervisors to kickstart this process. We have preliminarily negotiated an affordable software system to accomplish these goals. One of the best side benefits of this new technology will allow better communication and paper handling with law enforcement and defense attorneys. It's truly a win-win situation, with the citizen taxpayer being the biggest winner. My whole family is involved in public safety. My oldest son is in law enforcement. I am capable, I am committed, and believe me, I know how to prosecute and keep our community safe.
I want to thank both of our candidates, and folks, it's time to clap now. Thank you both. Thank you. Nice to meet you, too. Thank you.